everyone, and welcome to the daily newspaper analysis by LawSikho. So today we will be taking forward the discussion for 14th and 16th January. Before moving further, everyone, here is something I would like to share with you all, that this is going to be the last newspaper analysis that will be coming in my voice. This definitely is giving me a lot of mixed feelings. And before I begin, I would like to thank each one of you for being a listener to this newspaper analysis. As I have been coming up with this, like the LawSikho and my voice has been coming up with this from the last more than 2.5 years now. And this really gives me nostalgia as well as jitters to think that this will be the last time that I am recording this newspaper analysis. But any which way, I would definitely like to show my gratitude and thankfulness to all of you. And also, I would like to take this opportunity to wish each one of you all the very best. And to tell you all that just keep working hard, everyone. Things are definitely going to fall your way. And we are all going to have great times ahead. I think on this note, we can today start with the discussion. We have two editorials on our plate today. Both have been taken from the Indian Express. The first one is titled as Centre versus Delhi Government on Control over Services. So this basically is a tussle that has been going on between the centre and the Delhi government about the services, all India services and other state services as well. And we'll see as to what is the tussle and why, is it persistent between the two powers. Secondly, we have Personal Law versus Child Marriage Prevention Act issues before the Supreme Court. So that comes especially if it comes to the laws or the marriages in the Mohammedan law. So what is the tussle and what is the backing and the standing of Supreme Court on this will be seen here. Thirdly, we have the news update, and fourthly, we have legal news for the day. So to consider the first editorial for the day, Centre versus Delhi Government on Control over Services, a 5-judge constitution bench of the Supreme Court is between the Delhi government and central government over the control of services. Almost 5 years ago, the courts had witnessed a similar battle between the Aam Aadmi Party and the centre. So let's see that there is this bill, actually, the term, or let's see what the bill proposes, due to which the tussle is going on. So the term government in any law by the Legislative Assembly will mean Lieutenant Governor. And then the Assembly shall not make rules or committees to consider day-to-day administration or conduct inquiries. Rules and committee made before the new amendment comes into the force shall be void. So basically, the bill will define responsibilities in line with the constitutional scheme of the governance of national capital as interpreted by the Supreme Court. This is what is the contention of the Home Minister, basically the central government. Let's see that what are the reservations or what are the contentions of Delhi governments to this. The Delhi government is putting forward that Article 239AA of the Indian Constitution says that legislature can make laws on any matters on state and concurrent list except for issues relating to public order, police, and land. Now, the Supreme Court's Constitution Bench in 2018 recognized assemblies, right? That is the Assembly of Delhi, and said that the union has exclusive powers only in the above 3 issues. Then, the Supreme Court said that the Lieutenant Governor should work with the aid and advice of Council of Ministers. And the Supreme Court order clarified that the Lieutenant Governor has not been entrusted with any independent decision-making power. So while any matter of the dispute can be sent to the president, the Supreme Court said that it does not mean every matter should be. And then this is the final contention that they've put forward as the government, that after being rejected by people of Delhi, BJP seeks to drastically curtail the powers of elected government bill, and the bill is diluted of Supreme Court judgment. So basically, this could be definitely a power game going on between the two parties, the two powers. But let's see it into a greater detail. The matter of the tussle is regarding the control over the transfers and overall functioning of administrative services in the NCT Delhi. Please consider whenever we use this term NCT Delhi, it would stand for National Capital Territory Delhi. Now, of course, we know that when it comes to the union territories, they definitely have different kind of administration as compared to the states, because union territories directly fall under the administration, basically under the direct control of the central government. But with Delhi, the thing is that it is not just a union territory, but it is the NCT of Delhi, that is the National Capital Territory of Delhi. And that is why some functionings of Delhi may be different from the other union territories of the country. The contentions were regarding the following. Firstly, Article 239AA Clause 3 or Subclause A of the Indian Constitution talks about the special powers of the NCT Delhi. Then, the court held that it found no occasion to specifically interpret the impact of the wordings of the same with respect to entry 41 in the state list. In 2019, there was a split verdict wherein Justice Bhushan held that NCT of Delhi had no control over administrative services. And Justice Sikri, however, held that the Lieutenant Governor of NCT of Delhi had been divested with such power. So definitely there is some ambiguity going on as to whether or not the administrative services for NCT of Delhi would fall in whose ambit. In 2019 split verdict, that was caused due to the 2018 judgment wherein the court had laid down broad parameters for governance in Delhi. While Delhi cannot be called a state, the Lieutenant Governor of Delhi had only symbolic power and thus would actually have to rely on the elected government. So that would actually make more sense, because Delhi ultimately is a union territory. It is not a state wherein, the governor would have different chunks of power that, generally the governors have in other states of the country. Delhi, in this case, is a union territory, and specifically it is a national capital territory. And that is why it could be seen that, the functioning of the lieutenant governor or the powers of the lieutenant governor might be on the symbolic side, and rather than giving any real powers. But this act, so-called, or the bill basically, it seeks to give a lot of powers to the lieutenant governor, who actually was basically in the authority of the union government. Now, of course, you will believe here that the tussle here might be the reason. The reason for this might be that there are two different governments in Delhi and at the center. Possibly, if there would be same governments, as in the same parties would be governing both Delhi as well as the central government, then there might not be this tussle, keeping in mind that how political powers, the tussle for political power runs in the country. But this could be a chance that to take the control over Delhi, such tactics might be played by the union government. But of course, this should not be allowed if that is so the case. Then Article 239AA3A of the Indian Constitution was introduced by the 69th Amendment. Please note this, it's a very important question, and conferred special status upon Delhi as per the recommendations made by the Balakrishna Committee. According to the same, Delhi shall have an administrator as well as a legislative assembly. Let's look for the second article for the day that talks about personal law versus a Child Marriage Prevention Act issue before the Supreme Court. So the Supreme Court has agreed to look into the Punjab and Haryana High Court judgment that states that a Muslim girl, after she has attained puberty, can choose to marry anyone she likes. The Chief Justice of India has stated that the decision shall not be based on the precedents in any other case. Let's look into this at a deeper note. So according to the Mohammedan law or the Muslim law, any Mohammedan or Muslim who is of sound mind and has attained the age of puberty may enter into a contract of marriage. Further, even lunatics and minors can also be enrolled into marital contracts by their respective guardians. Please note that lunatics and minors can also be enrolled into the institution of marriage according to the Mohammedan law, given that the respective guardians are making such marital contracts on their behalf. Now, the NCPCR, which is basically the National Commission for the Protection of Child Rights, has moved the Supreme Court against the High Court judgment, and this provision in particular, stating that it violates the Prohibition of Child Marriage Act. Now, of course, when you talk about India, that is why many a times under Article 44 DPSP, a uniform civil code is many a times sought. But yet again, this is the issue when we talk about the UCC in the country, that there is a continuous contradiction between the universal laws that we have, be it the child protection, Prohibition of Child Marriage Act and the personal laws, because many a times they do not come or fall on the same page. Like in this very case, you can see wherein Prohibition of Child Marriage Act would provide that no person, would be married, like a minor, a marriage of the minor would be, voidable. And that situation, if at all, the Mohammedan personal law provides that the minors can get married. So definitely there is a contradiction of law over here. Now, in the case of Seema Begum, the Karnataka High Court held that no religious law would supersede the Prohibition of Child Marriage Act. So in a way, if at all we consider the judgment in Seema Begum case, we can say that the Prohibition of Child Marriage Act would prevail over any kinds of personal laws. But yet of course, we all agree to that real implementation of such laws then becomes difficult if at all they are in contradiction with the personal laws. Under the Act, the practice of child marriage is punishable, but the same is not illegal. It is voidable, as I just mentioned before, at the option of the minor party. So the NCPCR has also argued that such practices would also come under the ambit of POCSO. With this, let's move to the news updates for the day. Firstly, Men's Hockey World Cup starts in Odisha. It's an important news. Please keep a note of it. So, Men's Hockey World Cup 2023 got underway on Wednesday evening with a spectacular opening ceremony at the picturesque Barabati Stadium at Cuttack that was witnessed by thousands of hockey fans from across the country and abroad. Here is a question for you all. Do you think that India, this time in Odisha, is hosting the World Hockey for the first time, or have we done it any time before as well? Let me know in the comment section below. Secondly, Jai Hind, the new light and sound show. Home Minister Amit Shah inaugurated the Jai Hind, the new light and sound show at Red Fort in New Delhi. On this occasion, Mr. Shah said that the rich history and heritage of India has been presented very well in this 1 hour show. He said, those who do not learn from history cannot build a great nation. He called upon the people to make collective efforts to make the country number one in the world in the coming 25 years during the Amrit Kal. And of course, I hope that we all can take this lesson that history should always be the torchbearer, but we should never limit ourselves within the constraints of historical events. What we are to do today shall be open, and it shall always keep in mind that what is the need of the hour. So I hope we can inculcate in ourselves as well. Thirdly, Odisha government's Campa steering committee approves rupees 1,086 crore action plan for 2023-24. So Odisha government state level steering committee for Campa basically stands for Compensatory Afforestation Fund Management and Planning Authority. As the name itself suggests, guys, let me first tell you what exactly Campa is, and then we'll be moving forward with the news. So Campa basically, as the name is suggesting, it is like a compensatory system, a compensatory funding system, which is given for the purpose of rejuvenation and afforestation, keeping in mind if at all there was a forest land that was given for the non-forest use purposes. So to compensate for that particular loss, the Campa funds work. So compensatory afforestation fund management and planning authority, so that the balance of greenery and the balance of afforestation is always maintained. So this has actually approved an annual plan of 1,086 crore for 2023-24 fiscal, with focus on reducing man-animal conflict, which definitely has become a problem of today. Chief Secretary S.C. Mohapatra said afforestation programs are also to be monitored using Campa tracker and through satellite in every 6 months, and to be verified in the field through frequent inspection by senior officers. Fourthly, Home Minister Amit Shah releases a book titled Revolutionaries. So a book has been titled Revolutionaries, the other story of how India won its freedom, at a function in New Delhi. The author of this book is economist Sanjeev Sanyal, who is also a member of the Economic Advisory Council to the Prime Minister. Speaking on the occasion, Mr. Shah said that the country is celebrating Azadi Ka Amrit Mahotsav, and the Prime Minister has given a call for Panch Pran, of which the two important resolves are to remove any trace of colonial mindset and to take pride in our own roots. Fifthly, Bajaj Alliance Life Insurance and Punjab and Sindh Bank enter strategic partnership. So Punjab and Sindh Bank, a public sector bank, and Bajaj Alliance Life Insurance Company have entered into a corporate agency partnership. The partnership will allow public sector banks, new and existing customers, to avail a variety of retail life insurance products from BALIC, including term, savings, retirement, and investment options. It will allow BALIC, that is basically Bajaj Alliance Life Insurance Company, to offer protection and savings life insurance plans to banks' customers through its branch network. Next would be sixth number. I think there is some confusion with the numbers. Let's continue. European Union and NATO set up joint task force. So the European Union and the North Atlantic Treaty Organization have agreed to set up a task force to better protect critical infrastructure and increase resilience, top officials have announced recently. The task force, which will bring together experts from both the sides, will identify key threats to critical infrastructure and their strategic vulnerabilities, and propose mitigating measures and remedial actions. Here is a question for you all. Is India a member of NATO or not? Let me know in the comment section below. Next we have is that CBIC notifies the Customs Valuation Rules 2023. So the center has notified the Customs Assistance in Value Declaration of Identified Imported Goods Rules 2023, aimed at addressing the undervaluation of specified imported goods. The rules will be effective from February 11th, 2023. From next month, importers will have to furnish additional information at customs automated system while filing a bill of entry in case of specified goods. Next, government approves incentive scheme for promotion of RuPay debit cards. So the union government recently approved an incentive scheme for promoting RuPay debit cards and low value UPI transactions under the scheme. So these incentives are worth rupees 2,600 crore have been approved for the financial year 2023. The decision will help in building a robust digital payment system in the country. Next, a very sad news that came yesterday, Nepal plane crash. So at least 68 people were killed when an aircraft went down near the city of Pokhara in central Nepal. So the country's deadliest plane crash in more than 30 years. 72 people, 4 crew members and 68 passengers were on board the ATR-72 plane operated by Nepal's Yeti Airlines when it crashed. And there were also some Indians in the very same crash. Next, Piyush Goyal announces panel to redevelop land under 9 National Textile Corporation mills in Mumbai. So, Textile Minister Piyush Goyal announced the formation of a committee to speed up the redevelopment of land under 9 mills of National Textile Corporation in Mumbai. A total of 11 chawls existed on the lands of these 9 mills, and residents of these chawls will now get 405 square feet houses as compared to their current 100 to 150 square feet houses. Next, India won the series against Sri Lanka. So India defeated Sri Lanka on Sunday by 317 runs in the third ODI to clinch the ODI series by 3-0 against the Asian champions. The ODI win came after the Hardik Pandya-led youth Indian team defeated the Sri Lankans in the T20 series 2-1 earlier this year. Now let's see, what do we have for legal updates today? Firstly, exclusion of all Indian settlers from definition of Sikkimese in Section 1026 AAA Income Tax Act unconstitutional. Supreme Court has said so. So in the case of Association of Old Settlers of Sikkim versus Union of India, the Supreme Court held that the exclusion of old Indian settlers who have permanently settled in Sikkim prior to merger of Sikkim with India on 26/4, that is April 1975, from the definition of Sikkimese in Section 10 of 26 AAA of the Income Tax Act is unconstitutional. You can go through this for a further detailed explanation. Secondly, the grant of remission, presiding judge should give adequate reasons while giving opinion under Section 432 Clause 2 of the Criminal Procedure Code, says the Supreme Court. So the Supreme Court, in the case of Jaswant Singh and others versus State of Chhattisgarh, has held that the comprising justices Dinesh Maheshwari and Bela M. Trivedi, that while giving opinion regarding grant of remission under Section 432 Clause 2 of the CRPC, the presiding judge needs to give reasons with regard to the factors to be taken into consideration as laid down by the Supreme Court in the case of Lakshman Naskar versus Union of India. Thirdly, Supreme Court bench delivers split verdict in civil appeal for specific performance suit. So in the case of C. Haridasan versus Annapath Parakattu, Vasudev Kurup and others, the Supreme Court bench comprising Justices M.R. Shah and B.V. Nagaratna delivered a split verdict in a civil appeal arising out of a suit seeking specific performance of an agreement of sale. Fourthly, decision will be vitiated if materials are not disclosed to affected party, says the Supreme Court in the case of Deepal Anand Patil versus State of Maharashtra and others, that an adjudicatory body cannot base its decision on any material unless the person against whom it is sought to be utilized has been apprised of it and given an opportunity to respond to it. The bench comprising the Chief Justice of India, D.Y. Chandrachud, and Justice P.S. Narasimha held the same in a plea assailing a judgment of the Bombay High Court which upheld the order of disqualification of members of a cooperative society. Setting aside the order of the High Court and the appellate authority, that is the Ministry of Cooperative, the bench restored the proceedings to the file of the adjudicating authority, that is Regional Joint Director, Sugar. This was all for today. Thank you so much, everyone, for being there with us. And I really, again, wish you all the best. And thank you so much for being such patient listeners to our newspaper analysis with me. I hope that the same trend continues and that you all do great in your lives ahead. Thank you so much, everyone. May God bless you all. Take care. Thank you. Bye-bye.